Hello students, in this lecture number 4 on jurisprudence, we are going to discuss the definition of jurisprudence by Salmond, two senses by which jurisprudence can be defined by Salmond, scope of civil law as per Salmond, classification of jurisprudence according to two senses of jurisprudence given by Salmond, and in this lecture we will also discuss the extent to which the Salmond was agreed with the definition of jurisprudence by Austin and Holland. And at the end of this video, we will discuss that what are the various criticisms to the definition of Salmond. So without wasting the time, I am going to start my video. That this definition of jurisprudence given by Salmond is very popular among the Indian students. Salmond defined the jurisprudence as a science of the law. According to Salmond, jurisprudence is a systematic study of the law. And what is the meaning of law according to Salmond? By law, he means law of the land or civil law. According to Salmond, jurisprudence can be defined in two senses. And that senses are generic sense and specific sense. In generic sense, Salmond defined the jurisprudence as that it is a science of civil law. He says that jurisprudence is a science of civil law. Whereas in the specific sense, he says that jurisprudence can be defined as a science of the first principle of civil law. So what is the basic difference between these two senses? In generic sense, we will discuss the science of civil law in relation to any particular legal system. Okay. But in specific sense, we will study the science of the first principles of civil law without reference to any legal system. Okay. Salmond was agreed both with Austin and Holland, but not 100%, but only to the extent that jurisprudence is a science, is a systematic study of basic principles of legal system. Okay. Salmond was agreed with Austin and Holland, but only to the extent that jurisprudence is a science systematic study of basic principles of legal system. Okay. According to Salmond, civil law means law of the land or law of the state, which is applicable to only one country or to any one particular state. And this civil law is different from the general law. General law is that law which is applicable universally. Okay. Civil law, according to Salmond, is a law which is administered by the courts in the administration of justice. Therefore, we can say that according to the definition of Salmond, civil law do not include any moral law or any natural law, because it covers only that law which is administered by the courts in the administration of justice. So if any law is not administered by the courts in the administration of justice, that will not be the law according to Salmond. Okay. According to Salmond, jurisprudence in the specific sense includes theoretical jurisprudence. According to Salmond, jurisprudence in the specific sense includes a theoretical jurisprudence in which we will discuss the various fundamental principles of law, various fundamental concepts of the law, but without a reference to any particular legal system. For example, one of the fundamental principle, one of the fundamental concept of law is that ubi jus ibi remedium. What is the meaning of ubi jus ibi remedium? Where there is a right, there is a remedy. So this is the fundamental principle. So in specific sense, if we are discussing the jurisprudence, then we will discuss this fundamental principle of law without a reference to any particular country, without a reference to any particular legal system of any state. Whereas in the generic jurisprudence, we do not deal with the study of legal system in general. Okay. We do not deal with the study of the legal system in general, but we discuss with the general or fundamental elements of the law of a particular legal system. So, in generic sense, when we will discuss any legal principle or any legal concept that will have the reference to any particular legal system, that will have the reference to any particular legal system of the country or state, as the case may be. According to Salmond, in generic sense, jurisprudence can be divided in three categories. These categories may be systematic jurisprudence, legal history, and the science of legislation. When we are dealing with the contents of an actual legal system, and that actual legal system may be the present legal system or maybe the past legal system, without the history, without the development of that law, it will be called to be the systematic jurisprudence, in which we will deal with all the contents of any particular legal system that may be the present or may be in existence in the past. So what is written in the notes? Expository legal or systematic jurisprudence, it deals with the contents of an actual legal system as existing at any time, that may be existing at any time, which may exist in the past or in the present. Okay, and in the legal history, we deal with the historical process by which any legal system came into existence. So how a legal system came into existence? If we deal with the historical process by which any legal system came into existence, whether in the present or in the past, that will be the legal history jurisprudence. For example, if we are discussing how the present Indian legal system came into existence, so we are dealing with, in a generic sense, the legal history of India. Okay, and what will be the science of legislation? In science of legislation, we will discuss the ideal future of the legal system. Okay, and with the purpose for which it existed. For what purpose a particular legal system is existing in the present, and what can be the ideal future of that legal system in the future. That will be the study which will be done in the science of legislation. So according to generic sense, jurisprudence can be divided in three categories. First of all, systematic jurisprudence, in which we deal with the contents of the actual legal system. In the legal history, we will study the historical process by which a legal system came into existence. And in the science of legislation, we deal with the ideal future of the legal system. Okay. But when we are talking about the jurisprudence in the specific sense, then again the subject of jurisprudence can be classified in three branches. And that branches are analytical branch, historical branch, and ethical branch of jurisprudence. These three branches of jurisprudence correspond to the three divisions of jurisprudence in the generic sense, in which analytical jurisprudence will correspond with the systematic jurisprudence, historical jurisprudence will correspond with the legal history jurisprudence, and ethical jurisprudence will correspond with the science of legislation. And if we want to give the comprehensive treatment to the subject of jurisprudence, then all the three branches must be studied together. In the analytical jurisprudence, we will discuss the first principle of law with analytical approach. That means to say, the purpose of analytical jurisprudence is to analyze the first principles of law in greater detail. We will see that what are the contents of that first principles of law. Once we made the analysis, then we will see that what was the origin and development of that first principle of law in historical jurisprudence. Historical jurisprudence, the purpose of historical jurisprudence is to see the origin and development of the first principles of law. Okay, and in the ethical jurisprudence, we will deal with the law from the point of view of its ethical significance and adequacy. Whether that first principle of law is ethical to the society, whether that first principle of law is adequate to the society, If the answer is yes, then every approach will be made to incorporate that first principle of law into the actual legal system of any particular legal system of any particular country. In ethical jurisprudence, the purpose of ethical jurisprudence is to see with the law from the point of view of its ethical significance and adequacy. Okay, and according to Salmond, complete scientific treatment of any body of law involves the study of these categories mentioned above. Okay, so this was something about the definition of jurisprudence and classification of jurisprudence by Salmond. But there were two major criticisms which were faced by the definition of Salmond. The first criticism is that he narrowed down the field of jurisprudence by saying that it is a science of civil law. According to Salmond, only the civil law is a matter of study for the jurisprudence. He altogether ignored the natural law from the study of jurisprudence. In this way, he limited the scope of the study of jurisprudence. So what is written in the notes? The definition of jurisprudence by Salmond had been criticized on the ground that he has narrowed down the field of jurisprudence by saying that it is a science of civil law, and hence it covers only particular legal system. Secondly, he was saying that the scope of jurisprudence is not limited to, he was saying that law means that law which is administered by the courts only. But it is not true, because the scope of jurisprudence is not limited to the law which is administered by the courts, but it also includes study of other social facts. So in this way, we have complete our lecture. If you like my lecture, then please subscribe my channel. And for the notes of my lectures, you can go to lawarticles2020.blogspot.com. Thank you very much.